dive. We are jumping straight into the human drama at the heart of a really high-stakes Supreme Court of India judgment.
Right. The case of Malleeswari v. Suguna.
Exactly. So back in 2000, there was this partition deed that completely cut a woman named Malleeswari out of her family's ancestral property. The men in the family just, divided it up and simply moved on.
Yeah, but she didn't just accept it.
No, she fought back. She used the 2005 amendment to the Hindu Succession Act, which, for you listening, is the law that legally guarantees daughters equal property rights by birth. So she stepped up to claim her rightful share.
And that is a phenomenal starting point, because what makes this analysis so crucial for you is how this specific family conflict escalated. I mean, it morphed from a local property dispute into this massive, fundamental showdown over the finality of law.
It really forces us to ask a rather jarring question. Once a court drops the gavel, can a judge can they simply change their mind?
Right. And she actually won that initial fight in the Madras High Court back in 2022. But that victory sets up the procedural twist we really need to look at.
Which brings us to a woman named Suguna. She had previously purchased this property from Malleeswari's father.
And Suguna didn't take the standard route of appealing the 2022 ruling to the Supreme Court. Instead, she filed a review application.
Right back in the Madras High Court.
Exactly. And amazingly, in 2024, she convinced those exact same judges to completely reverse their own 2022 judgment.
Which is wild. And it brings us to the core legal conflict triggered by that maneuver. We're looking at the intense friction between appellate power and review power.
We all know the standard expectation. If you believe a judge got the facts of the law wrong, you appeal up the chain to a higher court.
Right, but review power is asking the exact same judge to fix a mistake in their own ruling.
But play devil's advocate for a second here. Suguna bought this property legally, likely without knowing the family dynamics. Didn't the high court step in precisely because they realized they had compromised a bona fide buyer's rights in that 2022 ruling?
That was absolutely the high court's logic in 2024. But the Supreme Court essentially said, tough luck. Sympathy for a third-party buyer doesn't create jurisdiction.
Right. They used this case to enforce the strict boundaries of Section 114 and Order 47, Rule 1 of the Civil Procedure Code.
Meaning review jurisdiction is exceptionally narrow. It absolutely cannot be an appeal in disguise.
Yes, but Suguna's lawyers decided to test the limits of that jurisdiction anyway, betting they could get the same judges to flip their own script.
And they almost got away with it.
They did. But for a review to be valid under Order 47, Rule 1, there must be an error apparent on the face of the record.
So we are talking about a glaring, obvious mistake. A blind spot so undeniable, it doesn't even require debate.
Precisely. If uncovering the supposed error requires a long-drawn, complex process of reasoning and reevaluating evidence,
then it completely invalidates the review.
Which is exactly what happened here. The Supreme Court looked at how the High Court reopened the entire factual matrix of the case in 2024 just to protect Suguna.
It ruled that they had unlawfully acted as an appellate court for their own decision. Consequently, the Supreme Court struck down that 2024 review and restored the 2022 order honoring Malleeswari's inheritance rights.
The real takeaway here is about judicial discipline. The Supreme Court is sending a definitive warning shot to lower courts. Do not let sympathy tempt you into overstepping jurisdictional boundaries and compromising the finality of property law.
This isn't just about one family's estate, though. For you, the general public, this judgment is a massive reinforcement of finality in our legal system. Losing parties cannot endlessly ask judges for a second bite at the apple just because they disagree with the outcome.
Plus, it powerfully reaffirms the real-world reality that daughters possess absolute equal property rights that cannot be conveniently brushed aside by a subsequent sale.
And for the legal professionals tuned in, the procedural lesson is stark. We have all seen lawyers try to creatively frame an appeal as a review just to avoid the appellate backlog.
The Supreme Court made it abundantly clear. Never draft a review petition as if it were an appeal. The boundaries of Order 47, Rule 1 will be strictly enforced.
It really forces you to think about the delicate balance of the justice system.
It does.
If the rules for reviewing a judgment are this rigid, demanding only the most glaring, obvious errors be fixed, where exactly do we draw the line between protecting the absolute finality of the law and ensuring judges have the flexibility to correct their own nuanced mistakes before forcing everyone into a lengthy, expensive appeals process?